In this video, we're going to talk about your power to trespass, or in other words, the rights that you have if an agent or someone that you don't want to be on your property comes to your property. And this is directly in reference to your private ministry or your private association. And great thanks to KrisAnne Hall at Liberty First Society for the breakdown of the ins and outs of the power to trespass and why you have the rights that you do. And of course, I will link this document. So if a government agent or assignee comes to your property, it's very important to those who wish to protect their property and privacy to know your rights. You do not have to answer any questions or make any statements to any government agent or assignee according to the Fifth Amendment of the U.S. Constitution and corresponding section of your own state constitution. Simply asking an agent to identify themselves does not waive your rights. You have the right to be free from any government agent or assignee entering your property, your home, or your business without a properly obtained warrant, according to the Fourth and Fifth Amendments of the U.S. Constitution and corresponding section of your own state constitution. If you demand a copy of that warrant, doesn't waive your rights. You have the right to tell any government agent or assignee to leave your property. Definitely recommend that you do this respectfully, right? We don't need to be causing any undue stress or angst between parties. If they cannot produce a properly obtained warrant, Fourth and Fifth Amendments of the U.S. Constitution and corresponding sections of your state constitution. Simply demanding an agent or assignee of the government to leave your property doesn't waive your rights. If the agent or assignee refuses to leave your property or returns to property after being warned against entering or returning, the agent or assignee has committed the crime of trespass and is subject to arrest. To state law, Fourth and Fifth Amendments to the U.S. Constitution and corresponding sections of state constitution as confirmed by Supreme Court opinions. You do have the right to record through audio, video, or photographic recording of any government agent or assignee on your property, either with or without consent of that agent or assignee. So you can record even if they don't know you are recording. This is according to multiple federal court opinions, recognize that First Amendment plainly protects the filming of officers and public agents. Hello, social media, as we've seen lots of recording. Sure, want to have is that no trespass sign either on the gate entering your property, a fence entering your property, the door to your property, wherever that is evident that you have a no trespass sign, and it's good to have your state code against trespass on your note as well. Points from the notice to the trespasser. So trespass is a general intent crime that usually requires no evidence that the defendant intended to commit the offense. The mere act of willfully entering upon, remaining in, or returning to any property or after being warned not to do so is sufficient to establish guilt. By state law, it is a crime if the offender defies an order to leave, if the offender opens a door, fence, or gate. Notice against trespassers, here's our notice, may be provided by posting, fencing, cultivation, or actual communication with your own voice warning. See state laws for the definitions of posting, fencing, cultivation. Warning may be given by the property owner or by a person authorized to do so by the property owner. If you're not home and you have someone house sitting or a family member that doesn't own the house, they are still authorized by you to give the no trespass warning. Again, should be posted. The inability to issue a written trespass warning to the subject does not prohibit a subsequent arrest for trespass. If there is evidence through a sworn statement or other evidence to establish when the trespass warning was given and that it was given to the same subject. By state law, an officer finding that a previously warned subject has returned to the same property without an invitation to do so may arrest the subject for trespassing. So you can call the sheriff if they continue, if they return, if they stay, because they are now committing a crime, especially if you have it posted. But as we just read, even if you didn't have it posted and you gave that verbal warning, they need to leave. A subject has been duly warned to leave or stay off the premises, even if these premises are a business establishment. By law, it is safe to assume that any invitation to enter was withdrawn. So if you said, oh, hey, hi, then find out who's at the door. And, oh, you need to go. You're trespassing. With all due respect, it's time for you to leave. That invitation to enter is withdrawn. Any return by the subject along with a complaint and proof of warning by the owner or agent justifies a charge of trespass. Persons acting as agents of the government may be trespassed. State and U.S. constitutions guarantee that every person is to be secure in their property from searches and seizures without a warrant based upon probable cause pursuant to the rules of due process. Agents of the government cannot simply enter private property based upon the color of law or a perceived need. I hope you like this video. I hope you like the information. Again, this will be posted below. Please like, subscribe, and share, and we'll see you in the next video.